Hi, my name is Jane McElligott. I'm a full-time faculty member with the School of Legal Support and Services here at Purdue University Global. And I am here to talk about the recently decided case of City of Grants Pass versus Johnson. This is a major case dealing with the issue of homelessness. Uh, and it has gotten a lot of attention, as you can see, many protests outside of the U.S. Supreme Court there on housing, not handcuffs. Um, and so let's take a look at the facts in this case. So Grants Pass, Oregon, is a city in kind of to the southern Oregon. Um, it has a population of 38,000. Of that number, about 600 individuals experience homelessness and have to sleep outside at night. So whether it be in their cars or with a blanket or in some kind of tent, but they have nowhere else to go. The resources are not there. Grants Pass has one shelter. It is a religious shelter, so it does offer some space, but for those who are unhoused, who aren't religious, that may not be an option because there are requirements in staying at the shelter. Um, so the weather there is fairly mild, so it is possible to sleep outside. So that is what is happening for a lot of the people who uh, have no place else to go. Um, so in 2013, grants passed because the number of unhoused was rising. Uh, the city enacted an ordinance. So an ordinance is just like a statute, but at a lower level because it's passed by a city or town. But the ordinance prohibited the use of blankets, pillows, and cardboard boxes while sleeping within the city. So basically criminalized being unhoused and sleeping outside at night. And along with that ban, it it imposed a fine starting at $295 if caught by police. If that was not paid, it would go up to $530. Eventually, it went up to about $1,200 in fines. And if a person is not able to, if they're sleeping outside, likely they don't have this kind of money, and probably the city knows that. Um, Also, the ordinance it has a potential penalty of 30 days in jail as well. Um, so the plaintiffs were three unhoused individuals who decided to challenge this ordinance. And so they brought a lawsuit to the U.S. District Court, which is the federal district court in Oregon. And they challenged the ordinance as being unconstitutional. So see what happened, and this is just a picture of some of the encampments in a park in Grants Pass. Um, so the U.S. District Court struck down the ordinance as unconstitutional and issued an injunction banning the city from enforcing it. This decision was affirmed by the higher court, by the U.S. Court of Appeals, and in doing so, the U.S. Court of Appeals relied on a previous Ninth Circuit opinion. Ninth Circuit is the federal circuit that covers a lot of states out in the West. So Oregon, California, Washington State. If you think of that whole kind of Northwest area, um, and and so in Martin versus Boise, the court held that the Eighth Amendment ban on cruel and unusual punishment bars the imposition of criminal penalties for sitting or sleeping outside by people experiencing homelessness who do not have access to shelter. So that by doing this, the court set up a kind of a approach where a city cannot penalize being homeless if it isn't providing the access to resources. So if a city is providing lots of access, but people just aren't using it, and there's no excuse why they're not using it, then they could criminalize it. But of course, in most cities, they're not able to provide these resources. And so the idea is if you're basically, when a city is criminalizing sleeping outside, um, they're criminalizing that person on the basis of status, on the basis that they are homeless. So let's take a look at what is wrong with that. Um, so the court, in addition to the Martin versus Boise case, the court relied on a previous U.S. Supreme Court case, Robinson versus California, from back in 1962. This is a case where uh, a California statute was challenged because it criminalized um, being a drug addict, the status of being a drug addict. So Robinson was convicted under this statute. The police didn't catch him using drugs or possessing them or selling them. Just simply, he was there on the sidewalk and he was arrested as a drug addict. Um, the US Supreme Court said, no, you can't do that. You can't criminalize someone for their status. And mostly because in criminal law, um, it's really an essential to prove the basic elements of a crime. You have to prove the mens rea, the guilty mind. That guilty mind triggers the actus reus, the guilty act, and there has to be concurrence. So basically, the guilty mind comes first, it triggers the guilty act, and the person does the crime. Well, when the city is or state is charging someone simply for their status as a drug addict, there's no guilty act and no guilty mind. So that cannot be the case. So because of that, this violated the Eighth Amendment. So the rule really coming out of that case was you can't criminalize someone because of their status. And in this case, of course, as a drug addict, the argument of the plaintiffs in the Grants Pass case is this is the same thing. We are being criminalized because of our status of being homeless. And as you can see, there's the Eighth Amendment. It's really the last part of the Eighth Amendment that is coming into play, that um, cruel and unusual punishments inflicted. So it's considered cruel and unusual if a person is convicted because simply of their status. Um, so that makes sense, but unfortunately, the U.S. Supreme Court overturned the U.S. Court of Appeals for the Ninth Circuit and upheld the Grants Pass ordinance. And Justice Gorsuch wrote the majority opinion. Justice Sotomayor wrote a very compelling dissent. She was joined by Kagan and Justices Jackson, Kagan and Jackson. So looking first at Gorsuch's majority opinion, the opinion of the court, so it was a lot of the decisions this past year have been 6-3. So the majority of the decisions voting to uphold the Grants Pass ordinance. The three more liberal justices, a lot more liberal justices, Kagan, Sotomayor, and Jackson, all really arguing that, coming up with good arguments as to why the Grants Pass ordinance should not be upheld. Justice Gorsuch basically held that the Eighth Amendment prohibition of cruel and unusual punishment is not relevant. Said, no, that applies to methods of punishment, after someone's convicted, not to whether the government can criminalize particular conduct. But Justice Sotomayor really called him out on that, saying that you're misunderstanding this ruling because that's not what the court ruled in Robinson. So this is one of those cases where it's really important to read not only the majority opinion, but also the dissenting opinion, because there's really different approaches, and the dissent calls out a lot that is questionable in the majority opinion. So Gorsuch concluded that the fines and potential jail sentence, which again are pretty hefty, $1,250 fine, possible 30-day jail sentence, said nope, those don't qualify as cruel and unusual. Again, not really thinking about the lack of resources, the lack of options. There's a link to an article there that is a good article talking about the implications of this case and how following the SCOTUS decision, if a person is homeless, sleeping on public property, it is now a crime, whereas that was not the case before. Um, in Justice Sotomayor's dissent, she started out with a very powerful sentence saying sleep is a biological necessity, not a crime. And she went on to say how really the people sleeping outside is their only option in Grants Pass. Again, um, there isn't the access to shelter in that city. And this ordinance even applies to people sleeping in their cars, or even just having a blanket to try to keep warm. So she points out that for people with no access to shelter, this is punishing them for being homeless. It's a status offense, really, which is unconscionable and unconstitutional. So she pointed out that the only question of the majority opinion went into the issue of homelessness and all of the, how cities and towns are trying to deal with it. And it is, of course, a major problem. And but he kind of focuses so much on the problem of the city and the town that he forgets the compassionate side that Sotomayor brings up. What about the people who are experiencing homelessness and, you know, something that anyone could end up experiencing if hit by the wrong conditions, by medical bills or whatever, loss of job, whatever it may be. So her opinion really brings out the the compassionate side of things, and points out that the Constitution. The big issue was does the Constitution allow this? Does the Constitution, specifically the Eighth Amendment, permit criminalizing sleeping outside when there is nowhere else to go? And she says with a resounding no, she gives the answer, and pointing to Robinson versus California. And she noted too that the city has the power, of course, to criminalize other things. They can criminalize, for example, if people have set up encampments on a public sidewalk. Of course, they can criminalize that because, it's blocking the sidewalk. Kids can't walk through to school. If they're blocking traffic, maybe the encampment has become a public safety concern. So there's lots of other ways, or say if there are drugs, many of the people in the town were complaining that that there were, for example, at the regular public park, sometimes there were needles left on the ground, which is awful, very concerning. But that could be a crime in itself, not the very fact that someone lays down to sleep at night, uh, uh, being the crime. Oh, sorry about that. Um, so Justice Sotomayor again really spoke to the heartbreaking crisis and did acknowledge both sides of the crisis. Not only the problems faced by the unhoused themselves, but also by the towns and cities and how to come up with resources to deal with it. But she emphasized again the Eighth Amendment prohibits punishing homelessness by criminalizing sleeping outside when a person has nowhere else to go. So really echoing Robinson, Martin versus Boise. And in Oregon, the state had codified, meaning they put the Martin versus Boise decision into their state's code. So in Oregon, the even in Grants Pass, even after winning this case, they cannot just start criminalizing this outright because that's going to be in violation of the state code. They have to first show that they're giving access to resources. So this may not change things hugely in Oregon, at least not for a while, but it could have a very harmful impact in other states where homelessness is a problem. And it could change from trying to come up with alternatives, tiny homes or more areas to, you maybe a designated park for people to sleep in or another shelter, kind of takes emphasis off that to just criminalize it. And that could happen in some states that are not still following the Martin versus Boise decision. So she pointed out that, this especially is a problem when the criminal penalties are selectively applied to minorities whose numbers are few, who are outcasts of society, and who are unpopular, but whom society is willing to see suffer, though it would not be willing to countenance general application of the same penalty across the board. Here she was speaking to Justice Gorsuch, had said that, tried to argue that these ordinances are not targeting the homeless. And he said, no, these would apply, say, if a backpacker was traveling through town and slept out in the public park with a blanket. Or if a college student is protesting and is out in a public park doing the protest at night and sleeping in a tent. But Justice Sotomayor said, no, this ordinance is aimed at the unhoused. It's not aimed at people traveling through town or students protesting. And so to wrap it up, Sotomayor concluded that I remain hopeful that someday in the near future, this court will play its role in safeguarding constitutional liberties for the most vulnerable among us. Because the court today abdicates that role, I respectively dissent. So again, a very powerful dissent by Sotomayor. And so I will, I did want to point out too that there's the link to the case, but there's also a good article on by Amy Howe on SCOTUS blog on this case as well. It's always a good source to check out for a little bit more on a case, a nice summary of the case. So that is it. Thank you for listening. Take care.